So you think the US patent system is unfair to inventors? You should see the European patent system. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. Hey, if you like this content, please do me a favor and like, follow, and share. I have seen a number of inventors who are disgruntled with our patent system and claim it is unfair to inventors. And I get what their complaints are. I understand why they feel that way. But just to give everybody a bit of perspective, I want to show you the European patent system, which in my view is far harsher towards inventors. So in the US, there is a prohibition against adding new matter to a patent application after you file it. You can amend your patent claims as long as any of those amendments are supported by what was in the application on the day you file it. But you can't just go add something new that wasn't in that application at all. Likewise, in Europe, there is a prohibition against adding new matter to a patent application after it's filed. However, their new matter rules have a very strict aspect that it really, in my view, is much more unfair, or at least much more limiting to inventors. And that is what they call the prohibition against intermediate generalizations. So in the US, if you file your patent claims, day one, and then you get hit with a piece of prior art and you need to amend your claims to distinguish it, it's usually no problem. You can grab a feature from the specification that you think is the best one for distinguishing the prior art while still giving you a valuable claim, and generally speaking, not a problem. In Europe, however, if you want to amend a claim based on an embodiment in the specification, you have to take the entire embodiment. Not just the feature you wanted to distinguish the prior art, but all the other stuff that's in that embodiment that relates to it. What does that mean? That means in order to distinguish the prior art, you now have to amend your claim to have a whole bunch of stuff in there that you really don't want in there and that you don't need to distinguish the prior art. And that leaves you with a claim that is very easy to design around. What this means is that when you're going to go into Europe, there is really important to have a real clear sense of the prior art and make sure you submit a claim set that really has all of the limitations you might eventually want to add to your independent claim in a dependent claim at the time you file it. Because if you get hit with prior art and you don't have it in a dependent claim and you have to pull it out of the specification, you're going to end up limiting your claims in a way that will really compromise the value of your patent. And unfortunately, I've had this happen to clients, and it's not a happy day when that happens. So yeah, we definitely have our imperfections over here, but just to give you a bit of perspective, there are other patent systems that in some respects are far rougher on their inventors. I hope that helps to keep you out of trouble, and I hope to see you here soon.